We're still on our interview segment, and we have another guest in the studio to talk about something extremely different, but also interesting and very important in our society. Our Wednesday today is all about the society and how we can push it forward.
Yes, we have in the studio this morning Barrister Dayo Adamolekun. He's a legal practitioner, and today we'll be discussing conflict resolution and the law.
Let's start from the grassroots. Let's start from, for a layman, what does conflict resolution mean?
I think before I get to that particular concept, let's break down the words. Let's deal with conflict first.
All right.
First of all. Now, conflict is from a Latin word called conflictus, meaning an act of striking together.
Okay.
So if you have a situation whereby two things are not on the same page, that strike, that means you have a situation of conflict.
All
so
right.
you can then say that a conflict is a situation or state of lack of harmony, or lack of agreement.
All right.
So, and I must also say that conflict is an inevitable part of life.
Okay.
There's no way you can avoid conflict in all human dealings or human endeavor. So it's actually part of life. And I must also say that people view conflict differently. Some people view conflict as just mere disagreements or difference in opinion or perspective, whereas some other people see conflict as a situation of war or conflict or trade disputes or any other serious situations whereby you do not have agreement as to a particular thing in issue. And now conflict resolution are basically the formal or informal process or procedures that has been established to resolve conflicts.
All right.
Basically, I mean, there are wide range of mode of resolving conflicts. So maybe by the time we get there, we'll be able to talk about that.
Okay, so what issues are permissible in court? What issues can you take to court? Let's start from there.
Well, let me start from the constitutional law standpoint.
Okay.
Now, there are some items that are not permitted to be taken to court. We call it, they are items that are not justiciable. So if you look at Chapter 2 of the Constitution of Nigeria, 1999 as amended, particularly if you start from around Section 13 to Section 23 or thereabout. Now, those particular sections make provision for the duties and responsibility of the government, be it the executive, legislative, and of course the judiciary. So these three arms of government are enjoined under the Constitution to make provision for certain things which are titled the fundamental objective and directive policy of states.
All right.
Now, under here, the government is supposed to provide free education.
Okay.
The government is supposed to provide for minimum wage for people. The government is supposed to make sure that people, it is to ensure social justice. People are to be able to have equal access to wealth, distribution of wealth. Now, if the two of you have the same degree, you should be able to be paid the same amount of wages and all. Then, under here, government is supposed to ensure welfare and happiness of every member of the society. But again, it's quite funny. The same constitution via Section 6, subsection CC, says that you cannot take the government to court for not doing all these duties,
all of these things.
All these things that I've highlighted. So that's one. Then again, now in law, you can almost go to court on anything once you have a reasonable cause to go do that. And once your action is not frivolous. There also you must also take into cognizance the fact that we have several courts in the land.
Yes.
We have the state high court, we have federal high courts, we have national industrial court, we have court of appeal and all that. So you must also understand that there are different courts have different issues that you can resolve at their levels.
All right.
Okay. For example, now, any matter that is beyond 10 million, you cannot take it to 10 million naira. If you are claiming for 10 million naira, maybe somebody is owing you and all that, or you are dealing with a property that has the monetary value that is beyond 10 million naira. So, yes, so you cannot take it to magistrate court. You have to take it to the state high court. Then if you have employment dispute, maybe somebody is being owed salaries and all that, arrears, entitlement and all that. There's a particular special court established for that, which is the National Industrial Court. So you know that's where you have to go. If you go to any other court, that matter will be thrown out because that's not the right place to go. Also, if it's just a simple contract, it's the state high court that has jurisdiction. There are matters that has to do with maritime, admiralty, and all, you have to go to the federal high court. So those are the different issues that we need to look at. So once your issue comes within a particular court, you know that that's the right particular court to go to. So, but if you don't go to that particular court, then the court will not allow you to proceed.
Now that we've highlighted the types of courts that we can take issues to and the kind of matters that are permissible in court, I'd like to know what are the modes of conflict resolutions that we have currently, especially in Nigeria, and how can it be resolved, really?
Yeah.
Oh, great. I think that's a very expansive, question.
Well, let's do it as...
Yes, so let me start by saying that the traditional mode of resolving conflicts is litigation.
Okay.
That's if you file an action in court.
Okay.
Right? Then there are other mode of resolving conflicts, which are called alternative dispute resolution mechanism.
All right.
Under here, you have what we call arbitration.
Arbitration, yes.
You have negotiation.
All right.
You have conciliation. And you have negotiation.
Let's take it again.
Yeah.
We have arbitration.
We have arbitration.
Yes.
We have conciliation. We have negotiation.
Negotiation.
And we have conciliation.
Okay.
Yes. Now, the one that is gaining ground now, which is actually serving as alternative litigation, because of the fact that litigation takes a lot of time and is very, very costly, very expensive, and is fraught with a lot of technicalities.
All right.
So arbitration is coming in now to just serve as an alternative to that. Now, by arbitration, it's just a private mechanism whereby parties agree that we're going to appoint a neutral third party to help us look at the disagreement or the dispute or the conflict between us and come up with a particular resolution, which is called award, and which is going to be binding on all parties.
All right.
Okay? So that's that. Then, if you're talking about negotiation, parties on their own just decide, okay, we don't want to fight too much, don't want to go to court because it's going to take us a lot of time. Okay, so let's just resolve amongst ourselves. Let's pre-bargain. Okay, maybe we are owing 10 million. Okay, I have only 8 million. Are you able to take this so that we can move on? So that one will resolve the issue in a win-win situation. Okay. Then conciliation too. They may just try to invite a neutral third party to let them, to table their issues, their grievances between the neutral third party. So whatever the decision that person comes up, so they decide to agree with it or decide not to agree with it. Okay. So those are the basic ways to resolve conflicts that would not necessarily mean going to court to slug it out. Because there is a particular adage in Yoruba land that you don't go to court and return as friends. Because if you go to court, the idea is not a peaceful resolution. It is to either affirm that, okay, this person is right, this person is wrong. So at the end of the day, one person is going to be aggrieved. That's the truth of the matter. One person is going to be aggrieved. But in alternative dispute resolution, arbitration, conciliation, negotiation, and all that, so the two parties agree from ab initio to say, okay, rather than going to court, we want to submit to a neutral person. Help us look at this particular case dispassionately. Help us come up with a resolution. If you agree, fine. If you don't agree, then at the end of the day, you still have to revert back to the traditional mode of dispute resolution, which is litigation. You know.
So recently, I saw something about breach of promise to marry.
Good.
I did not know something like that existed because I just feel I got engaged to you, but I don't feel like continuing.
It's not legal binding, so.
But then I saw that it is recognizable, as it were, in the court of law. So how do you go about that? Do you take such matter to court, or you resort to negotiation or whatever?
Yes, you can actually take that to court.
Oh,
really?
Promise to marry, in a way, is a contract. But again, it has to fulfill certain ingredients of contracts, of a binding contract. There has to be an offer and acceptance.
All right.
And as a matter of fact, consideration. Now, for example, okay, I promise, okay, I will marry you. Maybe December 2019. It's okay, I accept to marry you.
All right.
Then, as a result of that, I begin to invest in you, you know, you were taking another. At some point, you decide, okay, I'm not doing it again. That can actually be enforced.
But there is no written agreement or no written contract. So how does that work?
Very well, very well, very well. Now, in law, we have written agreements, we have written contracts and contracts by paro. Contract by paro are contracts that are not written, that are just made by words of mouth. But the most important thing is once we are able to show, once you can list some evidence to show that you have actually furnished some consideration. Like I said, you have maybe gotten an apartment for the person, you will be paying the person rent and all that and all that. You are able to come up with evidence to show that, okay, you have actually made some commitments into this particular investment, so to say. So then you should be able to enforce that particular contract. Yes.
Okay, so before we end the show, I'd like to know very quickly the role of lawyers and judges when it has to do with conflict resolution.
That's very interesting. I must say that I think conflicts and lawyers, they're like twins. You know, you can hardly separate the two of them. You know,
They are friends.
Yes. So lawyers are actually there to resolve conflict. In fact, not only resolving conflict, they are even there to avert conflict coming up in the first place.
All right.
But sadly, a lot of people do not think about lawyers until they have one problem or the other. But ideally, my advice would be that if you are going to any particular venture, contract, whatever, you want to do any particular investment, it's good, ab initio, from the start, to get advice from lawyer to say, okay, these are the things I want to go into. They will be in position to advise you so that there won't be any reason for that particular contract to go awry, for conflict to arise in the first place. So lawyers are very, very critical. So from the beginning, it is good, lawyer is very critical so that to avoid conflict. Then if conflict eventually happens, lawyers is very critical to actually act as advisor, then to represent litigants in court. And at the end of the day, if there is judgment, lawyers are also critical to enforce that particular judgment. In law, you can almost go to court on anything once you have a reasonable cause